Quiet on the set.
Hi, I'm Carl Pearson, a New York attorney and a graduate of Harvard Law School, and I represent homeowners and small businesses throughout the United States in foreclosure litigation, foreclosure defense, wrongful foreclosures, quiet title actions, loan modification efforts, and all of this is to make the mortgage more affordable for the homeowner with a loan modification as the end result, and hopefully including a principal reduction. This video is number 114L. It's called Finding a Local Attorney, and it's the last in a series of 12 related videos. The 12 videos are being prepared for viewing in sequence from A to L and provide an up-to-date look at defending foreclosures. A preliminary discussion is that I know your problem. I've heard it thousands of times. You can't find an attorney in your area who are willing or sufficiently experienced to take on your case. Let me tell you what I think are some of the major reasons and then what I'm doing about these problems. Here are the reasons, not all, but a lot of the major reasons why you're having trouble. 1, you're calling the wrong type of lawyer. Real estate lawyers are transactional. They prepare deeds and loan papers, but they generally do not go into court as litigators, and especially against banks, which the lawyers depend upon for financing of their clients' home purchase matters. 2, law firms with 2 or more partners. They don't want your single transaction, low-dollar legal business for fear of losing the more lucrative work they could obtain from financial institutions. They don't want to be tainted by representing persons whose interests are against the bank's interests. 3, the attorney is not experienced in this type of litigation and doesn't want to put in the number of hours it might take to learn the field for a single low-paying client. 4, you come from a non-judicial foreclosure state in which there are little or no foreclosure actions in which an attorney could obtain experience in defending foreclosures. 5, you come from a non-judicial foreclosure state in which injunction actions and preliminary injunction motions generally do not succeed in stopping a threatened foreclosure because the judge too often concludes that there's not enough evidence to demonstrate that the homeowner is probably going to win the lawsuit. Now, I caution you right here that if you have a breach of contract by the bank and they didn't give you a promised loan modification, that probably is sufficient evidence for you to be able to obtain an injunction. So remember that don't be your own lawyer here. These are issues for a lawyer to help you out on. 6, you called the Bar Association and they were of little or no help because they did not have a category of law for foreclosure defense. As an aside, the category of lawyer most appropriate, in my opinion, is a commercial litigator, such as myself, with many years of litigation experience in securities, real estate, businesses, franchises, antitrust, patents, trademarks, copyrights, admiralty, fraud, breach of contract, defamation, injunctions, and some bankruptcy. 7, you were not able to sufficiently articulate your legal problems to encourage the lawyer to represent you. 8, you may have spent too much time impressing the lawyer with the legal information you obtained from hours on internet when you should have been seeking the lawyer's opinion on what you really should be doing. 9, the persons you have talked with seem to be selling something other than legal services, such as a short sale or a securitization audit, or were not in fact a law firm. Anyway, you and I know that you have had trouble finding an attorney in your county. There are 3,000 counties in the United States and relatively few litigating lawyers, judging from the number of decisions that I've seen coming down from the courts. If there are 100 favorable decisions, 50% of them come from one judge in Brooklyn. The other 50% come from 3,000 counties in the United States, so that there is only one favorable decision in every 60 counties on the average, disregarding that Brooklyn. Also, decisions are not consistent, so that one favorable decision is not necessarily followed by all, most, or even any other judges. Solution. The solution to me seems to be twofold. 1, commence the quiet title action in New York, on the grounds that the note was last transferred in New York, and that the transfer is governed by the New York Uniform Commercial Code. At the present, this may raise venue issues in which the servicer and bank may move to dismiss the action on the alleged grounds of improper venue. If this occurs, the action can be quickly refiled in your own county and state, but with a need for a local attorney at such time. And actually, there is ample justification for the action in New York, and it's being litigated right now, so it isn't like that venue issue is a lost cause. It's just in litigation right now. 2, instead of bringing a quiet title action in New York, you could bring a quiet title action or any other lawsuit, such as an injunction action, in your own county and state. I can help you locate a willing, suitable attorney at a price range or hourly rate that is appropriate. I am probably more able than the client to find a local attorney because I'm experienced in this type of litigation, which will be quickly realized by the local attorney. If the attorney needs assistance in order to take the case, I can offer such assistance to the attorney, which gives that local attorney a chance to create a new market for himself or herself in defending foreclosure matters locally. 3, I've had no difficulty in any state seeking and finding a suitable local attorney. 4, I'm perfectly willing to have the local attorney do as much as he or she wants to do, and on the other hand, do as much for the local attorney as he or she wants me to do. This is a good working arrangement and similar to the way a major law firm works, with different levels of skill doing different things to provide quality services at the lowest cost. 5, if you want to talk about quiet title actions, please give me a call. 6, the action has several causes of action, including a declaratory judgment action and usually a claim for loan modification fraud if appropriate. It is not a classic quiet title action such as between two homeowners in court to determine who owns a 1-inch strip of land between the two homes. In a real quiet title action, it would relate to real property, whereas my quiet title action relates to the promissory note, which is not real estate. A real quiet title action would advertise to give notice to anyone in the world claiming ownership of that 1-inch strip, but my quiet title action does not attempt to give notice to the world for the purpose of inviting others in the world to make claim to the note. If you'll think about it, you don't want the lawsuit to have others start thinking about they may have an interest in your note. You just want to see whether the people you sue have an interest or whether you can prove that they don't have an interest. So, number 7, in summary, there are many lawyers in the country who are willing and able to work with me or other experienced foreclosure defense lawyers to provide quality representation to you in your own county and state. So I'm finished with this last video in this 12 video series called this video is called Finding a Local Attorney. If you haven't seen the rest of them, you are invited to do so. The first video is number 103A, entitled Once Upon a Time Before MERS. If you have any questions, please give me a call. My telephone number in New York is 212-307-4444. I provide free consultations and represent homeowners and businesses throughout the U.S. as to their foreclosure problems, including the saving of properties through loan modifications and principal reductions. Remember, there are no guarantees of result in litigation, and once again, my number is 212-307-4444.